Okay, well, welcome everyone. I'm Lainey Feingold. Excuse me, glad to be here. So we have an hour and a half. I do have a slide deck to share with you structured negotiations, which is a way of practicing law that I have done since 1995. Kim, when she wrote her first book, called me and said, well, you know what you do is integrative law. So do you want me to interview you for my book? I'm like, oh, I didn't know that. And I have written a book about my work. We'll talk about that. And I don't know how many of you have written books, but writing a book is not as easy as it sounds. And one of the biggest stumbling blocks for me is my entire practice is disability rights, representing disabled people, and in particular, representing blind people on technology issues, making sure blind people have access to technology. And we could talk about that, what that means a little bit. Now I do consulting. I work with a lot of companies. And the hardest thing about writing the book was I feel like this method that my clients and co-counsel and I have developed is so useful for disability rights, and therefore it has to be useful for everything else. And I kept trying to write about how it would work in other contexts and realized that that's for you all to decide. That's for the readers to decide, because what I know is how this method has worked in disability rights. And that's what I'm going to share. And I think it has application beyond disability rights. I think it overlaps with all the different kinds of legal practice and sectors of legal profession that you'll hear about during this symposium. But you'll have to decide for yourself. So it'd be great to know who all you are. If everyone could, does everyone have access to the chat? If you do, if you could just, say where you're from, and are you a lawyer or a law student, or what other role you have, that'd be great, because it's always good to know who you're talking to as a speaker. So yeah, and like I said, I have a deck. We have a small group, which is really nice, so we'll have plenty of time for questions. I'll keep an eye on the chat, but if you have a burning question while I'm in the middle of something, just either shout it out. That hand raise thing doesn't work too well when you have the slideshow because it's hard to see all the people. So I don't know, maybe Aubrey, if you see a hand raise, you can just interrupt me, or you all can interrupt me. Don't consider it interrupting, consider it starting a conversation. So, and if we're running out of time, I'll move it along. But yeah, so let's see. I have one person in here, Rising 2L. Yeah, oh, more. Okay, Alexis, hello. Rising Junior at Yale University. My name is Julia. I'm a law student from South Africa. Lovely. Yeah, I love speaking with law students. I actually, through Kim's connections, and because the American Bar Association published the first edition of my book, I got to know more academics in the dispute resolution field. Someone wrote to me recently and said she asked her students to do a reflection about the class. And one of the students wrote something which she gave permission to share with me. And that thing was that she had read my book before she started law school, and it gave her the kind of confidence that there was a place in law for someone like her. And, I hope that if you're in this room, you are someone who cares about collaboration. You're someone who wants to do law differently. You're someone who's creative and courageous and wants to explore. So hope you get some ideas for however you want to practice law, however you do practice law, or like Professor Fast here, who sounds like you're like me. We've been at it for a long time. I'm 41 years this year, 42 years. So yeah, so let me share the screen and we'll get started. Law lecture from Port Elizabeth, South Africa. I was very jealous of Kim's trip to South Africa. We have in our field of digital accessibility great work being done on the African continent, particularly in Kenya, and there's an annual conference that just finished up last week called All Africa Accessibility or something. by a nonprofit called Enable. And it's pretty much the only thing on my bucket list to do in the next 2 years, get down to that conference. So I hope that I do. I hope that I do. Okay, so let's go. I will share my screen. I will put up the PowerPoint. I will ask you all if you can see it. I believe you can. We're good. I have a slight little song for the front page. Doesn't work so well on Zoom because we're all talking, but I'll just give you a 10-second clip.
Try to see it my way. Do I have to keep on talking till I can't go on? Why you see it your way? On the risk of knowing that our love may soon be gone. We can work it out. We can work it out.
So I do have a song deck to go with my slide deck that I use when I do longer trainings on structured negotiation. And there is a great playlist for dispute resolution put together by a professor named Noam Ebner. If you don't have it, I can make sure the organizers get it and post it. But I like that song to start because that's really what I've been doing for the last 27 plus years is trying to work it out. So I titled this Structured Negotiation, 27 Years of Disability Rights Collaboration. And I have on the title slide the name of this institute. I have my website, which is lflegal.com. I do a lot of writing about both accessibility for disabled people to tech and also about collaboration. I got rid of the copyright on my website last year. Everything's Creative Commons. So I invite you to take it and use it for the good. And if you have any questions about anything on there, reach out to me. I have my Twitter handle, which is @lflegal. Twitter is in its dying days here, so it's also my handle on Mastodon. You can find me on LinkedIn. And my book is called Structured Negotiation, A Winning Alternative to Lawsuits. It's in its second edition. In the background of the slide, you can see a dolphin smiling up from the blue waters of the slide deck. And we're going to talk more about dolphin later, but shorthand, structured negotiation is a way not to be a shark in the practice of law. And I learned of a book about 5 years ago called Teaching Baby Sharks to Swim. And it was a book for new lawyers. And I do a lot of public speaking, and I'm like, I need a sea mammal, sea creature metaphor for this practice because I have never been a shark. I don't want to say never, but in this practice, I've never been a shark. I don't want to be a shark. I don't think it's an effective strategy when you're talking about disability rights and many other fields. So I did a little research. I talked to some friends actually who were marine biologists, and they suggested the dolphin. And we'll find out as we go through why it is that a dolphin is a much better representation of the kind of lawyer I want to be and the kind of lawyer that this practice really not just requires us to be, but teaches us how to be. It's constantly learning. So what's the roadmap for today? For the roadmap picture, I have a picture of a road in Northern California. This is Highway 1 in Marin County. I'm in Berkeley, California. I have worked here where I live for the last 27 years, and I work out of my house. Way before COVID and pandemic and remote work, I left a nonprofit job, which I very much liked, but was too much work. I have 2 kids who at the time were 10 and 7. And I said, I'm going to work out of my house, see what happens. And in part because of this collaborative practice, and in part because of wonderful co-counsel I've had over the years, I've just been here with no staff out of my upstairs bedroom about 30 minutes from this road picture. So I want to talk about what is structured negotiation. I want to share some stories. I want to give you an overview of all the elements. I want to talk about the ideas and the practices that infuse the elements. And I want to go into detail on some of the elements, depending on how much time we have. So what is structured negotiation? So the first thing is a win-win approach to resolving legal claims without a lawsuit. That is how I have practiced it. And I'll tell you in a minute about how it all started, but I used to be a little, I don't want to say braggy, but I'm like, oh, I've accomplished these things without a lawsuit. And that was like the hallmark of what I thought it was doing. And then after I wrote the book, came out in 2016, began doing more trainings and speakings about this. I discovered that structured negotiation is also a collaborative way to limit cost and conflict once a lawsuit's filed. So I haven't used it that way, but other lawyers have, which we'll talk about, because these are skills and strategies. It's all about skills and strategies that allowed me to avoid a lawsuit altogether. Some people prefer to have the lawsuit on file for various reasons, various good reasons, but structured negotiation allows for collaboration within the lawsuit. And then lastly, structured negotiations has proven to be a collaborative strategy to bring people together to solve problems. So my field is digital accessibility, as I said, which has to do with how blind people use technology, how deaf people, how people who can't hold a mouse, how people with ADHD and cognitive disabilities. So there's a whole world of that. And that is really my primary community, almost more than disability rights lawyers. So I do a lot of public speaking, here in the US and outside the US to accessibility people who are in companies, in government agencies, who want to build technology that works for people with disabilities and are in a constant process of having to convince decision makers to spend money on it. So I once did a talk and I was introduced by a guy who was a developer for government agencies. And he said, your book, changed how I work. And I'm like, how could that be? He wasn't a lawyer, whatever. And he said that he goes, before reading your book, I felt the only way to get a point across to leadership was to focus on winning by means of individual merit as opposed to collaboration. That ultimately shaped the language I used, and it also made me miserable. Reading your book changed that, not putting folks on the defensive, using persistent and positively framed language, avoiding military metaphors, and not mentioning so-called experts, and sticking to facts without over-dramatizing changed the way I worked. And he goes on that. So that has changed my definition, because I feel and that's why I feel this practice has potential application to whatever fields of law you all practice in, because being collaborative and seeing collaboration as a strategy is something that has benefited people in my field who aren't lawyers. So that's that. I'm just going to look a quick look at the chat and make sure yes, thank you for saying welcome, newcomers. So let me just say one quick thing about digital accessibility. So blind people can't see the screen. So when I'm presenting, you might have noticed on the front page, I said what was on the screen. I described the dolphin. Deaf people can't hear video. It has to have captions, and we have captions on this presentation today. People who can't use a mouse can only use a keyboard, and a keyboard could be used with a hand. It could be used with a stick, various ways. It could be used with eye tracking. So accessibility is really the quality of technology that makes it possible for people with disabilities to interact, to create, to be consumers. So if you have any questions about accessibility, I have a ton of stuff about accessibility on my website. We'll take a break in a bit, and you can ask me particular questions if you want. And it's also the law. So I've been super lucky to have this I'm kind of at the intersection, I say, of technology, of dispute resolution, of disability rights. So that's that. So that's what structured negotiation is, those three things. Let me get back in here. Structured negotiation depends on trust. It depends on listening, and it depends on relationships. And I put a picture of a chessboard here because I see these things as strategies. A lot of my friends in disability rights are phenomenal lawyers. And when I first started talking about this, sharing about this, it was kind of like, well, you have that personality, I could never do it. And first of all, not always do I have that personality. I certainly didn't have most of it back when I started this. But all the stuff we're about to talk about, in order to build trust, to have relationships, and to do listening in a way where you're really listening, those to me are skills and strategies, which is why I like the chessboard. I think they can be learned. I think they can be practiced. And I think pretty much anyone can do them. Not everyone, but anyone on this call, I can guarantee you can do them, because you wouldn't be here in an integrative law gathering if you couldn't. So we'll talk about how we establish trust in these kinds of civil rights cases that I do, how we build relationships, and how we really have to listen, which is not something our profession really encourages. I remember with my kids, it was always like, I'm listening to them, but I have the solution. I have this. I'm like, don't worry about how you're feeling. I'm going to fix it for you. Not that good if we're trying to build relationships, to have a collaboration, to bring about long-lasting change. So just a few stories to give a setting. I have the dolphins in the background jumping. The whole thing started in the financial sector. And this is a picture of a talking ATM. So a talking ATM is something that blind people can use. Plug in a headset into this jack here, which this is a picture of sort of an older model, and the jack is elevated off of the face of the ATM. You plug it in and you get all the instructions you need to use the ATM if you can't see the screen. There's also a sign. It says audio jack. There's an arrow pointing to it. It's in Braille. And in 1995, none of this existed in any ATM anywhere in the United States or anywhere in the world. In 1994, 1 year before, well, not, in 94 and 95, it didn't exist anywhere. So 94, blind people came to my colleagues and I and said, there's not a single ATM in the whole country we can use. Americans with Disabilities Act was passed in 1990, was 4 or 5 years old when we started. Is there anything we can do? And for a variety of reasons, we were, one of which was being scared of bringing a case for new technology that didn't exist and screwing up the ADA for all times. Another reason was we had an experienced lawyer. I was young and not experienced, who always ended up settling the cases that he worked on in civil rights, and said, well, maybe we should start with trying to settle instead of filing a lawsuit. So we wrote to Bank of America, Wells Fargo, and Citibank, and we said, there's a problem here. There are blind people who can't get access to their own money. They have to share their PIN with strangers. They might be in a taxi and have to give their PIN to a taxi driver. Will you work with us to make ATMs that blind people can use? So I have a big, long piece about this in my book. For now, just know that much to our surprise, the bank said, yes, we'll sit down with you. And it was not a warm and fuzzy sit down. We were very aggressive with that first letter. We'll talk about the letter in a bit. But we were coming off of a litigation mindset. Wrote a very strong letter. We had a complaint attached. We're going to file this if you don't talk to us. Just very aggressive. Now I look at it, I'm like, oh my God, that was like a tank coming in there. Meanwhile, it worked to have them sit down. We had an amazing experience over 3 or 4 years. We had a very strong group of blind people who are our clients, which has been the key, the kernel, the reason for the success of this method. Is very client-centered, and in disability, blind people know best about how to make technology that works for blind people. Deaf people know best how to make sure captions and sign language interpretation, either live or on things like Zoom, work best, etc. So we had those blind people, we had the banks, we had the meetings, we had testing, we had all of these things, and by 1999, we had the first talking ATM. It was not the first talking ATM in the world. That was in Canada. I don't know if anyone here is from Canada, but if you are, thank you for that. And it was my first taste of the global nature of working in the technology space, because we found out about Canada. Remember, it was like very early in the internet, but we found out about Canada. Again, it was because of advocates in Canada. They got a one-off built by Royal Bank of Canada of 6 ATMs that talked, found out who built them, brought the guy down to California, met with him in a room, a meeting I'll never forget. And I'm like, wow, was it expensive? He goes, you people in the United States, all you care about is how much things cost. This was a really important thing we did. Anyways, his information helped. We got to talking ATMs. In 1999, one of our clients came to us, and again, our clients, I can't even express what it's like to be a lawyer in this space where the expertise is not, it's not a law thing. It's really a client-driven thing. And one of our clients came to us and said, Lainey, good job. We got these ATMs that talk. We need that. We need independent access to our money. But there's this new thing called online banking. And it was new. Nobody knew online banking. This was like 97, 98. And they said, we better make that accessible, because if we can't access the websites of our banks, we're not going to be able to get access to our own money. We're going to be back to square one. So that's why I have this picture of a keyboard with the tab key replaced with the accessibility, because we went to Bank America and we had a relationship. We had a relationship with Bank America because we hadn't sued them, and we had collaborated, and they had seen the merits of our clients as people, as customers, and not just as plaintiffs. And we said, we got this new thing, online banking, we got to work together. And they said yes, and we did. And by 2000, we had the first web accessibility agreement in the country. So it was like an amazing experience. And when it was over, we had agreements with all three banks, Bank of America, Citibank, and Wells Fargo. We got the technology. We did other things like make sure there were Braille statements and other things like that. We got money for our clients under California state law. And most importantly, we got, well, not most importantly, but one sort of factor we'll talk about later, we got paid because in the United States, for those of you who don't know, in civil rights case, in the United States, mostly you have to pay for your own lawyer. But in civil rights cases, disability, race, gender, the fee obligation shifts, and the person who company that discriminated has to pay the fees of the disabled people. Well, we hadn't done a lawsuit, but we had the relationship. And we did use a mediator in that case to help us work out the fees. But we did get the fees without a lawsuit. And for those of you who are in the United States, you probably know that's a big deal. And for those of you outside, I can assure you it's a big deal, because whenever I speak to US lawyers, they're like, first thing, how do you get paid? And how does fee shifting work? Because there's a lot of bad case law about being able to get the fees if you haven't filed a lawsuit. We'll talk in a minute how we do that. But meanwhile, it worked. And we said to ourselves, was that just luck? Or are we onto something that can be replicated? And we decided we were onto something that could possibly be replicated. So we came up with this name, structured negotiation. I had wanted to call it collaborative law. Collaborative law, I'm not quite sure the history, but by 2000, it was firmly established in the family law field. And I talked to some of the family law people who explained to me that in family law, collaborative law, you kind of have to agree at the outset that if it doesn't settle, as a lawyer, you'll leave the case to somebody else who will file a lawsuit, which doesn't work in the civil rights context for various reasons, which I can talk about. So we had to come up with another name. Had I known it would eventually be more of a thing and I'd write a book, I would have probably thought of something catchier than structured negotiation. But we wanted to do that to say, this is something real. This is an alternative to litigation, not pre-litigation negotiation, not something less than, but something equal to. And we were representing a lot of nonprofits who, in the course of their work, did do negotiations, but we wanted to say, this has a structure. This isn't a casual conversation. This is something with a structure. And that's how we got the name structured negotiation. And we ended up going forward and doing this process with most of the banks that existed at the time. Now, of course, has been consolidation. There's not as many banks. And it kept working. So we wanted to keep doing it. Other areas we've worked in the health sector. Didn't work with major pharmacies on talking prescription labels. This is a picture of a billboard in an airport somebody sent me that is from CVS Health that says, for those who can't see, pill bottles that talk. Oh, we did the talking prescription label, again, something that didn't exist at the time at any major pharmacy. There were some third-party vendors offering products. There were no lawsuits, and there still are no lawsuits. We've done this structured negotiation process with CVS, with Walmart, with Walgreens, with all the big pharmacies. So it was successful there too, and the same kind of thing. Blind people who had experience and could share the experience as people, because without a talking label, blind people do things like put one rubber band on one medication and keep it in the kitchen so they can keep it separate in their minds from the bottle with two rubber bands that they keep in the bathroom. And once we were able to be in real conversation with pharmacists, they could see the safety and health hazards of this kind of thing. So that was successful. We've worked with healthcare organizations on various things like accessible websites, getting information in print. And, we'll talk a little bit about this later, but both of these, I'm just reminded that this practice has had a really good impact on people we would otherwise call the opposing counsel. And I recently, as I was cleaning things out, let's see if I can find it here. Well, I don't have it right here, but I have this wonderful email from a banking, I don't know what I do with it right now, but wonderful email from one of the banking people who work for a bank who was like, when I saw your client get so excited about taking her own $20 out of a machine, that shifted how I work and will always shift how I think about my job as a banker. And we have that same kind of feedback from the people on the so-called other side of the pharmacy cases. So in all these cases, we try to find the point of collaboration, which we'll talk about when we talk about the details. So yeah, we've done it in the health sector. It's been used in prison and jail cases in Illinois, California, and Washington State. It's been used with accessible pedestrian signals. This is a friend of mine, picture of a friend of mine, Jerry Coons, in San Francisco with a talking audible pedestrian signal, which San Francisco didn't have any before we did this collaborative process. So it has worked in the public sector. We've done it with transit agencies. It's been used by other lawyers, not me, in voting rights cases to make sure blind people have independent access to voting rights. This is a picture of a kiosk. Other lawyers have used the process to make sure that, now there are these types of kiosks. This is the kind that sits on the table in a restaurant. You should be able to pay without having to share your PIN. If it's not accessible, you can't. So structured negotiations has worked for that. In the mid-2000s, when checkout at grocery moved from technology with a keypad to a flat screen, and at the time, flat screens were not accessible, we worked with 12 national retailers, again, without a lawsuit, to Target, Walmart. And these are companies that usually hire lawyers that don't want to so-called settle. And this process created an environment in which they could say yes to working with their customers. CVS, Rite Aid, Radio Shack, some of these companies don't exist anymore, but we did it in retail. It's been used in the education setting and both of these pictures are about cases I was not involved in. One is a process they used in a college. One is a process they used in an elementary school. In the college case, the plaintiff was so instrumental in explaining to the college how it was they needed to be accessible that after the case was over, they actually hired the guy. Imagine somebody you're suing, hiring someone who sued them. Wouldn't usually happen. We've done it in entertainment. This is a picture of a movie screen. Audio description is technology that inserts text for visual images in movies, both streaming and in theaters. So the process has worked in that. Probably one of the more popular cases I did was with Major League Baseball, and an incredible group of blind baseball fans who one phone call and they were off to the races to fix the barriers on the website, which just for context, include things like if you're listening to the radio on the website, which many people do, what if the volume button hasn't been coded properly? So if you're blind, you don't hear where the volume button is, or you can't change the stations. So we work with MLB on that, still have a wonderful relationship. It's been used in an employment context. The only time, there's a couple of things I know where outside of disability rights, the process has been used that people have told me about. One is this case against Lyft by the Sisters of Perpetual Indulgence, which is a drag theater ensemble in San Francisco, who were having problems getting Lyft to pick them up. And so structured negotiations was used to create new policy for Lyft to make sure that these gay, trans, drag queens were not discriminated against by Lyft. I've done a training for the transgender legal organization here who are using the process in their work to make sure health insurance policies cover surgeries and medical care needed by people who are trans. Okay, so I'm just going to double check the questions. I look forward to catching the rest of the recording. Okay, well, thank you. I'm glad it's being recorded. Within a lawsuit, people have used this process for employment ADP, which is the company that provides technology software for employers to keep track of time and all that. When it's not a big problem of hiring disabled people, and inaccessible technology is a big problem there. Here they filed the lawsuit and then they pivoted in the middle to structured negotiations, got a wonderful result. It's been used, I said, in prisons and jails, both without a lawsuit and within a lawsuit. This is a picture here of a wheelchair user coming up on a curb ramp and a sidewalk. There's been lots of curb ramp cases. People sometimes sue to get cities to install curb ramps. Sometimes they sue and pivot to structured negotiation, and sometimes they have started with structured negotiation. Okay, so I want to do an overview of the elements. That's kind of the story foundation, so you know how it's been used. Okay, the elements, the structure part one. The image here is of a honeycomb and a bee on it. And that's because in the first edition of the book, which was published by the American Bar Association, I self-published the second edition. In the first edition, they gave me a cover I had no choice over that had a bunch of hexagons as a background. I'm like, oh my God, this thing looks like a chemistry book. I hate this cover. Finally wrote a book, don't like the cover. However, optimism is a quality that we have to practice in structured negotiations. So I did a lot of research on hexagons and discovered they have a lot of qualities that we actually practice in structured negotiation. Hexagons make up a honeycomb. And the reason the shape is so strong, it's like, there's a million examples in nature and in architecture, and that's because it's strong and flexible and long lasting. There are these, I forgot the word now, these things that come out of the water that, I have an article on my website if you're interested in hexagons. So I use that as the image. The very first step, and we'll dive deeper into some of these going forward, but everyone has to be on the same page about collaborating. If you want to try structured negotiation and your co-counsel is like rolling their eyes and thinking this is a waste of time, you're going to have problems down the road. When I turned the book into the ABA, they sent it to the East Coast, and the lawyer wrote back one thing, said, how the hell does she find clients who want to work like this? How does she find clients who aren't angry and want to fight and want to give bad press to companies? So I have been extremely lucky in my practice that once we did this in California with the banks, the people attracted to the method are the people who want to use the method. People are attracted because they don't want to file a lawsuit. I mean, it's my belief that with proper explanation, most people would rather not be in a lawsuit. It can be, expensive, it's emotional, it's stress, it forces compartmentalization. You can't be your full person, you have to be plaintiff. So it's really important to make sure everybody's on the same page of collaboration. What's it going to mean? Second part of the structure is writing the first letter. We'll talk about that more. I call it an opening letter, not a demand letter. Who wants to answer a demand? So there's a lot of things about how do you make that first contact that will leave the person somewhat at least open to working with you when you're telling them in the same letter, this work that you're doing or this barrier that you've created is actually a violation of a federal law called the Americans with Disabilities Act. That's the main law we've used. There's others as well. So I should say that at the outset, like I said, do a lot of speaking to the accessibility world outside the US that doesn't have such a strong legal foundation as we do. And the strategies can be very useful, I think, in countries that don't have the strong legal foundation. But here in the US, it very much helps that we are able to say in the letter, and we can talk about how to do that, that this is a legal violation without hammering someone over the head with the very first paragraph being you're in violation of law, you're a discriminator. So we have an opening letter. Then we have to wait for the answer, which is really an element of structured negotiation because lawyers are not that good at waiting. Excuse me. I didn't really realize that this was an element until I was, started doing more training and really breaking down. I mean, one great thing about teaching something, as those of you who are professors know, and maybe even students receiving the information, you really have to, I did this thing for, 20 years before I really thought, what is it that we are doing? What makes this structure of structured negotiation, and waiting with patience is a very important aspect. So once we get a response, the next element is ground rules. We'll talk about that in a little more depth. We don't have court rules, so we have to have ground rules about what is this negotiation going to be about, how is it going to be constructed, how is it going to be conducted, what do we do for discovery alternatives, because we need information and we don't have discovery because we don't have a lawsuit. How do we handle experts? One of the best parts of this, which we'll talk about also, again, this is just the overview. One of the best parts is that the clients themselves can be experts. Not something applicable in every field, but applicable in most fields. And at the very least, the clients are the experts of their own experience. I've been lucky that my clients are experts in the thing we want. When we worked on the accessible pedestrian signal case in San Francisco, one of the clients was writing a master's on accessible pedestrian signals, and one of them was on the statewide advisory group about what is accessible pedestrian signals. So I've been lucky enough to have experts in the solution as well as experts in the lived experience. But in most cases, someone comes to you because they have their own story, and this process gives people the opportunity to be experts of their own story. We draft an agreement. Once you get to that stage, pretty similar to drafting an agreement without having so much baggage of having fought for X amount of time beforehand. Talking about money, I have always measured myself. Those of you who were on the call yesterday, I dropped in the idea that, I was always worried, am I getting the same results as people who are suing? Because we were new to the field was new, and there were other people doing these same issues with lawsuits. So it was very important to me and to my clients to make sure that clients got money that they were entitled to, and also that we got paid attorney's fees so we could keep this going, because that's been the entire business model. I've never gotten paid by a client until I recently started consulting. What kind of media strategies do we use? The most important thing to know about the media is that we do not start out with a bad press release about the bad things the organization is doing. Because who wants to do something for someone that has just shamed you in the press? So that is a big difference. When I wrote the book, I did interview almost all the opposing counsel, partnership counsel. And one of them said to me, the best thing you have going for you in this process is that you don't do a press release when you contact us. Because in a big firm, this was a big company, this was a very large company, he said, the lawsuits stay in the law department, but the press releases, the chairman of the board gets a call from the next door neighbor. So that's been a really important strategy. And then we monitor and implement, which is critical in all civil rights cases. Infusing all the elements. Let me just check the chat real quick, see if, okay, we're good. Okay, does anyone have one or two quick questions about the stories or the element overview? And then we'll go into what impacts all the elements. No questions? You can either raise your hand or you can shout out, unmute yourself if you want to talk. Okay, so infusing all the elements. This is a picture of a foundation in New York City being built. It's such a large, it's like, I think 1 or 2 square city blocks in New York, 2 cranes, because these things are the foundation of structured negotiation. Talked about the elements, did the overview, but the foundation impacts. Without the foundation, you can't really have any of the elements. Attention to timing, collaborative language, and collaborative mindset. Attention to timing, collaborative language, collaborative mindset, infusing all the elements, everything we do from writing the opening letter to setting up the first meeting to writing the ground rules. We have to pay attention to timing, to language, and to mindset. So we have no court rules and no scheduling order and no autopilot, which is I have my cute picture of the blow up autopilot with a big red X on it, and a old-fashioned push autopilot on sign with big red X. So we are used to, as lawyers, to having rules that someone else imposes. And in this process, we don't have court rules, we don't have scheduling orders. And this impacts things in 2 ways, well, many ways, but one is in a regular lawsuit, there's a roadmap that you have to follow so it feels like you're doing something. And this is something we have to talk about with our clients, like, we're not going to report on, well, we have this court hearing and we got this scheduling order and the answer's coming in this amount of time, because there's nothing to say that has to happen. So it all has to happen based on our ability to convince whoever we're trying to make change with, to convince them that they have a problem that they want to fix. So it's really important. It's related to timing. To just remember, things aren't just going to happen. We have to make them happen with the strategies. So the kinds of timing, I have a picture, timing is everything. When do we introduce the ground rules? We used to attach the ground rules to the opening letter and then realized that's kind of heavy. Like, people have never heard of us. They've never heard of the process, and we're sending them something to sign. Now we don't do that. We write a letter. And when we have the first conversation, we say, well, you know, if you want to do this, we have to have ground rules, because we have to, you know, can't be on autopilot because we don't have court rules. So we have to pay real careful attention to that, to the timing. Making public statements, like I talked about, we don't want to make public statements early because we don't want to, well, we just don't want to be critical of someone we're hoping will make change with us. When we gather information, what's too soon, what's too much? When we share draft language, is it time? Is it too early? Is it too late? I mean, those of you who've been in negotiations and taken negotiation classes, I'm sure you've talked about this, but in a structured negotiation, like most negotiation, if you give someone a full-on settlement agreement too early, they're going to be like, oh my God, I didn't know it was going to cover this, that, and the other thing. This is too much. But if you give it too late, in our kinds of cases, you run the risk of a company saying, well, you know, we're already doing these things. We don't need the written agreement. So how to share the draft language is a strategy. Everything is very intentional. Usually what I do is ask the counterpart lawyer, you know, we try not to use the word opposing counsel, but the lawyer representing whoever it is we're negotiating with, do you think it's a good time to share language? And usually they'll say yes, and then it's off. We're not shoving it down someone's throat, but we have agreement, collaboration. Yeah, now it's time to have language. If it's too early to have language, but we're concerned that some of the issues may be falling off the table, like we always try to do training. And in accessibility, there are a lot of issues like testing and usability studies and many things. So sometimes we give a punch list or just a sheet. Just want to make sure we're all on the same page about these are the issues we're going to be talking about. So all of these things have to do with timing, including pivoting to a different strategy. Structured negotiation may not always be the right strategy, and it might be a strategy that you start, but then it doesn't work as you anticipated. I think if you, for those of you who read my book, or those of you who don't, I can just give you a shorthand that if anything, I have been too patient and too not willing to pivot, not willing to throw in the towel, because the result, each positive result builds on the next. So I'm always like, we'll give it one more month, or we'll give it one more this. And it doesn't work for all cases, all subject matters. There's also pivoting to a different strategy while you're holding the structured negotiation. So we've had cases where there's some pending lawsuit somewhere else in the country that would really impact our ability to get the results we want for our clients. So we've kind of paused the structured negotiation, done an amicus brief in another case. Once we had to pause the negotiation because there were going to be federal regulations and we wanted to be involved in the regulatory process, which I will say, I don't know about your fields, in disability rights, I've been involved in probably 6 or 7 regulation processes. The federal government issues various regulations on disability rights, and our agreements are always finished before the regulations. And our agreements, in some cases, have been the model for the regulations. That's what happened with the talking ATMs as well as other things. That we got the talking ATMs. We had such a good collaboration that the ATMs really worked. So when the federal government wanted to do the regulations, we basically lifted all our technical requirements and that became the regulations. Words matter, attention to language. The word plaintiff comes from a French word that means wretched complainer. Couldn't believe that when I researched it. And that's, especially in the United States, this is how people who file lawsuits are seen. In our field of disability rights, I had from 1995 to 2016, where we had not that many lawsuits and people weren't seen as wretched complainers. Starting in 2017, maybe you've heard about this, there has been a new kind of lawyer come into the space, filing lawsuits. I don't think they're ethical lawsuits. I've written about this. Last year, in 2016, there were 57 lawsuits on accessibility of websites. Last year, there were over 4,000. So we have a problem in the field. And when it first started, it was so devastating to me because anyone who entered the field, I'm always like, welcome to the field, and I have a relationship with Bank of America. If you ever have a client with a problem, call me. And, I'll introduce you to the lawyer at the bank, or I'll fix it for, whatever. I don't want your client. This new cast of lawyers came in. It was like, first time I talked to one of them, literally, I got off the phone with tears in my eyes because he was basically, fuck you. I don't have to call you. You've been making money off these people all these years. So now we're operating in a universe where people do think of the plaintiffs as wretched complainers. And that is why I'm opposed to those lawsuits, primarily because of the harm I think they do to disabled people. And back in the day, even not knowing wretched complainer, even not knowing these type of lawyer that operates in many fields in this country, I knew we didn't want to be plaintiffs. So we use the word claimant. Now, does it matter to the company we write to? Maybe not, but it matters in my head that I'm always aware of. We want to make it clear that they're claimants. And I have had lawyers for the big companies say, I know you don't call them plaintiffs, Lainey. I know you don't like that word, but yeah, so we use claimants. We use opening letter instead of demand letter. Try not to use opposing counsel. Very hard to get out of that habit for me, even though I feel very close to many of the lawyers that I work with in this process with big companies. And we also don't like to use the word defendant because we don't want people to defend their bad behavior when they get our letter. And that's kind of how the whole litigation system works. You get the letter and it's like, oh, you have to defend yourself. So I think this is a process that can be used by people getting sued. If they get a letter, if they get a lawsuit, they can try to use these processes and don't have to defend. They don't have to say, yeah, what we did was right, because, oftentimes it isn't. So even the word discrimination, I'm a civil rights lawyer, and excluding disabled people from the digital world is discrimination. I personally don't think the word discrimination is that helpful in an opening letter to convince who you're writing to want to work with you, because no one wants to see themselves as a discriminator. And what does it get us? Everything has to be run through the lens of what is the goal for the clients, and just calling opening letter like, you've discriminated against my clients, is that going to help establish the collaborative space that we want to operate in? So that's where I come down, for anyone using this in disability rights or in any other field. Well, in any other field, it's going to be other language. Are there trigger points? Are there things that press people's buttons? Can we stay away from those words and still get the results we want? We always want to have testing of products and services by our clients. And so we wrote language in one agreement, and we said, the clients will test this. I don't remember what the product was. And the other lawyer wrote back, and he's like, absolutely no testing. Our company doesn't believe in testing, can't have testing. I'm like, well, that's critical, blah, blah. All it needed was feedback. He wanted, your clients can give feedback, they just can't test. Did it matter to us? No, didn't matter at all. We wanted our clients' experience in the corporate ecosystem. Feedback, testing doesn't matter. The key thing that matters, paying attention to the words that we use. Okay, attitude matters. Here's the shark. Here's the shark song from the Jaws theme song. Yeah, so like I told you, I don't want to be a shark, and you don't need to act like a shark. And here's a picture of the goldfish with the shark fin, because most of us in the field, in traditional lawyering, feel like we have to act like a shark. And my experience shows that you don't really have to. You don't really have to. Now, it has gotten easier for me to take the shark fin off, having done this for so many years, now considering myself an elder in the space. But even early on, it's good to be thinking, do I have that shark fin on? And do I really need to have it on? So I put an X over the goldfish with the shark fin. Be a dolphin instead. First of all, dolphins are very cute. I don't know if you can hear the dolphin sound. This is a picture of two dolphins getting food out of a plastic container. And it's a National Geographic experiment. You can look it up. And they had to work together to get out the food. Dolphins communicate. Dolphins strategize. There's a lot of great things about dolphins. I did a training on structured negotiation in Australia, and I said, well, dolphins, like there's this TV show in the US, it's called Flipper. Have any of you guys ever heard of it? And I thought, well, first of all, they're in Australia. Second of all, the show's been off the air for a long time, and I'm always the oldest person everywhere I go. Someone puts up their hand and said, yeah, it's kind of like Lassie, a water lassie, like Lassie the dog. And then it turns out in Australia, check it on YouTube, Skippy the kangaroo. And all three of these creatures, the dolphin, the lassie, they're so popular, so beloved, and you know what? They saved the day. In the end, they saved the day. There's some conflict, and their skills get the job done. So it's human nature in all aspects of our lives to be more dolphin than shark in our neighborhoods, in our families, in our spiritual communities, in our office. So why do we have a profession that kind of seemingly rewards the shark, even though in fact it doesn't? So yeah, so I like the dolphin. Everybody loves dolphins. Imagine if we could achieve a reality where everyone loved attorneys. Anthony Noahs, thank you for saying that. I have done a talk once and someone said, well, I think you're really misunderstanding the role of sharks in the ocean ecosystem, and went on about how good sharks are. I'm like, it's a metaphor. Good, like sharks, don't want to kill sharks, but lawyers don't really have to act like them. So, okay. So some of the mindset dolphin qualities: active patience and persistence. This is a picture of a thorn and a rose. And the reason I have that here is because there's a wonderful quote from Rumi, who, as you know, probably was a Persian poet in the 13th century. Patience, I'm reading it here. Patience is not sitting and waiting. It is foreseeing. It is looking at the thorn and seeing the rose. It is looking at the night and seeing the day. Lovers are patient and know that the moon needs time to become full. I love that. I love that. And I call it active patience because when we're waiting, we send the opening letter and then we're like, oh no, what's going to happen? It's not twiddling the thumbs. It's knowing that if you send a letter to an organization, we're working with, Fortune 500, 1,000 organizations, big nonprofits or government agencies, but even small companies. You get a letter from a lawyer, it takes time to figure out what to say. You probably want to get your own lawyer and you got to talk to your people. So having active patience, and by the active part is the week before, I say in the letter, please respond by December 1st. Again, that's no court rule. Why do they have to respond by December 1st? So, at the end of November, I'm like, did you get the letter? And is it in the right hands? And can you, always staying on top of it, but understanding things take patience. And the other patience image I have here, this is a blind surfer from, I think, Brazil. I just lost his, Derek Rebello. And there's actually a movie. It's called Beyond Sight Movie.com. And he's a third generation big wave surfer, totally blind, waiting in the ocean to get the wave. And just like little images to put in our minds, like, wow, in his field, he has to wait patiently to get a wave. He's totally blind and he's a huge big wave surfer. Like, we can't wait an extra 10 days without throwing in a towel and filing a lawsuit. So I like these little reminders. Active patience, important dolphin skill. Don't make assumptions. Your assumptions are the windows on the world. Scrub them off every once in a while, or the light won't come in. As lawyers, we are constantly making assumptions. Someone's late in answering, we think they're blowing us off. Someone doesn't give us information, we think they're hiding the ball. Someone makes a monetary offer, we think that's all they have. So we just have to step back and look at our thoughts and say, are they really blowing us off, or did the letter get lost in the mail? Is he delaying on purpose, or did his mother die last week? Things happen to people. I think now there's much more understanding of that in, I don't know, the legal profession, but the world at large. I have the quote attributed here. It says Alan Alda, not Isaac Asimov. If you look it up online, you can see many people say it's Isaac Asimov, but my research shows it's actually Alan Alda, but you can let me know if I'm wrong. So challenging assumptions is important. Finding the yes. I love this quote from B. Smith, who was a U.S. media personality. And she said, I stood on a mountain of no's for one yes. So true. And doing collaborative law in a world where things are contentious. When we write the letter and they write us back, it's know this. We didn't violate the law. We gave your clients what they needed. The law doesn't require it. No. Usually buried in there is maybe not even a yes, maybe just the why of a yes. Like, however, we're happy to have a phone call. It's all we need. Just one tiny little opening. Sometimes I show a picture of a closed door. Tiny little opening. And that's part of the mindfulness skills that are really required for this, is to find that and not to jump into assumption, not to jump into defensiveness, and to say, we wrote a whole big letter. We were lawyers. We said why it violates the law. Let's read the letters we get back. Let's listen to the phone calls that we have and find the yes in that. Exploring fear, another important dolphin quality. Just doing a time check. Fear is a liar. That's what the billboard says in this image. And the quote is, fear is the path to the dark side. Fear leads to anger. Anger leads to hate. Hate leads to suffering. Yoda in the Phantom Menace. First of all, in my line of work, a lot of people are afraid of disabled people. And it's a fear that comes from not having what we call disability proximity, not knowing disabled people. So this process breaks that down by bringing people in a room together and keeping it client-centered. There is fear all around the table, including our own fear of, what's going to happen in the negotiation. Fear is always there. We have to find it. My fear acronym: find, explore, appreciate and address, and respond. I will give you one quick example. I can't remember if it's on the next slide or not. When we worked with the pharmacies on talking prescription labels, the pharmacists in the first meeting in a couple cases said, we're afraid if we have talking labels, a blind person might hear it, misunderstand it, take the wrong medication, and die. Seriously, this is what they were afraid of. If we were in a contentious environment, we would have written to a judge, this is ridiculous. Right now, blind people get no information. If all they get is a print label, how can they say that blind people will misunderstand? But you know what? I honestly feel that the pharmacists we talked to really felt that. They really were afraid. And the only way to get through fear is get through it, not around it. And meeting blind people and hearing stories like I mentioned about how blind people have to take medication without labels. That's all it takes to explore it, appreciate, address it, and respond to it. Audible pedestrian signals, that give audible information and tactile when it's safe to cross the street. The traffic engineers, same thing. What if they mishear? What if they don't hear it right? They step off the street and they get hit. And with no audible or tactile feedback, you have no idea what's happening if you can't see the no walk sign. And again, it was being in the room with people with the lived experience, not putting a hat on them that says wretched complainer, but rather real person. The traffic engineers got it. If we had been in traditional litigation, we would have been like trashing their fears instead of trying to understand their fears. So that's a real important dolphin thing. I have a slide here with my fears. I love this picture, resist fear, assist love, which I recommend you look up. I think his name is Nathaniel Russell. He put it up on his website and he said, use this freely. Don't make money off of it, but use this freely. Usually I don't talk about love. Sometimes people say to me like, well, what about love? And I know integrative law is a safe space to talk about love. So I put this slide up there. Usually I don't talk about it when I'm talking to traditional lawyers for sure. But I'm always had fear things. We're not going to get the ground rules signed. They're not going to do the fix. We won't get the fix fast enough. We won't get any money. They won't sign the document even once we negotiated the agreement. We're going to get complaints from the community because we didn't do everything right. We're not making any precedent. We're not making legal precedent. We do make industry precedent, which has been very impactful in the world I operate in, but we don't have any precedent. So these are all things I am fearful of. So I'm also having to check my own self because each of these things would be cause to throw in the towel if I wasn't aware of them. Thank you for putting in a soundtrack case. I will save the chat. I will remember to save the chat right now so I can add that song to my list. And the results. something I'm always been afraid of, which has been a motivator to make sure everything I do is right. But you know what? Our fears are just like the fears of anyone around the table. They have to be looked at. We have to see why we have them, and we have to take steps to address them. Optimism, very important. Optimism is the faith that leads to achievement. Nothing can be done without hope and confidence. No pessimist ever discovered the secret of the stars, or sailed to an uncharted land, or opened a new doorway for the human spirit. Who said that? Could have been Ted Lasso. If you guys are watching Ted Lasso, he's big on hope and faith, but in fact, it was Helen Keller. You got to keep an optimistic attitude in this process, because otherwise, too many opportunities to throw in the towel. So I consider that another dolphin skill. Listening is so important. This is a picture of older woman, probably a mom and a child, speaking sign language to each other, really listening, not traditional lawyer listening, but active listening that I know is important in all aspects of integrative law, really important here. Empathy, not sympathy. You know, empathy is a word in disability rights that's a little loaded, because sympathy is not a thing that you want, but we want to create empathy so people understand that the reason disabled people can't use the internet is not because they're blind, it's because it wasn't coded to be accessible. That's a short answer. So this is the empathy helmet, which is a true thing. You can look it up, Simon, the empathy helmet. We put it on and you can track the brain waves of the people you're negotiating with. Also, the point of view gun from the Hitchhiker's Guide to the Galaxy. We point the gun at someone and you get they get your point of view, you get their point of view. Really important to create empathy. And I know this sounds a little Pollyanna-ish, but I truly feel that this process has brought these big companies, including their lawyers, to a different mindset, because it's very hard to be angry and yelling and aggressive when the people on the other side aren't. So if we model, I really believe that, brainwave exchange thing, empathy neurons, we model these dolphin qualities, we're going to get them back. And it has happened. Practicing equanimity, not getting riled. Best example I have of that is a meeting we had where the guy, I'm 5'2", the guy on the other side stood up the whole time. He was like 6'5", and he was yelling at us, "We will never do what you want, blah, blah," slammed the door, left, and we were just, okay, what's the next step? Eventually we got the agreement. Flexibility, being kind, having appreciation, trust in relationship, being grateful. Being grateful piece is important, because chances are you can find something good that the person that you're negotiating with has done. Talk about that in a minute, about the letter. So just to think about, do you consider yourself a dolphin or a shark or a hybrid? Which of these qualities are the hardest for you, which come naturally? Again, in an integrative law environment, I just assume that everyone wants to cultivate the dolphin skills. When I have a 6-hour training, I do a 3 and a 6-hour training, and I do a breakout session where people talk about who they are. And mostly people say that they're somewhat of a hybrid, but the profession kind of pushes them to the shark. So it's really good to know that you can have a career, for those of you who are law students, where you can be more of a dolphin. So again, dolphin skills are strategies. They're not personality traits. They're strategies for client success. And I just want to do a little bit on some of the elements, a little bit deeper. Does anybody have any questions, comments before I go forward? Okay. Okay, getting everyone on the same collaborative table. And this is a picture from a website called Disabled in Here, which has stock photos of disabled people, people of color, people who are LGBT, and they're all sitting four women are sitting around a table. One's in a wheelchair, one is a cane, having a business meeting, because you have to get everybody on the same page, like I said. most of all yourself. You have to know you want to try to work in this way, because there's plenty of opportunities to give up along the path. The co-counsel, the clients, the retainers, and the co-counsel agreements need to reference that we have separate retainers for collaboration, and they specifically say if the collaboration structured negotiation doesn't work, we have to have a new retainer for the lawsuit. Fortunately, I've never had to do that. Cases have always either worked out or in a couple instances not worked out, but not worth pursuing in a lawsuit. So getting everyone on the same page, do the opening letter, which we also call an invitation to negotiate, because a lawsuit is like a punch in the face, which is this cartoon character of a punch in the face with an X on it, as compared to an invitation. And in the book, I quote an opposing counsel, a counterpart lawyer for a big firm, who said, it's really different getting the invitation letter. That's how she phrased it, than getting the typical lawsuit. One thing I can say about the opening letter, find the lion. I love this image. It's of a cat looking in a mirror and seeing a lion. And this is to say that every person, every organization sees themselves a certain way. And in our field of disability rights, and I think in most fields, that part of the job is to show how what we need, what our clients need, fits with how the company or the public sector agency sees itself. So for one little example, we worked with the American Cancer Society, who produced cancer information in about 50 languages, and they had no Braille, no large print, no audio, and no online accessibility. And we had a blind client who has since died of the cancer that she needed the information for. And we were able to write in the letter, like, you guys are great at providing information in all these languages. You need to expand that a little to meet your goal of being the best cancer information provider and provide it in a way that blind people can access. So I spent a lot of time on the websites and the press releases of the companies we're writing to see how they see themselves, and show that if you don't have an accessible website, blind people have no privacy. You're a leader in privacy. You've got to care about this too. Anything designed to be independently used, if it's not built with accessibility in mind, the privacy is broken. So finding the lion is key in the letter, and saying something good about the company. One last example, we wrote to a big financial company, and they were generous. They had a fund. They funded disabled groups. We put that in the letter. In a lawsuit, it's hard to say something nice about someone because you're afraid it's going to come back and bite you. Here we said, you're so generous to disability nonprofits. What we're asking for here is in line with your mission, So when we do negotiations with retailers because their technology doesn't work for disabled people, we can say, you have great customer service in your store. Getting better technology is in line with what you're doing, with how you're seeing yourself. So that's a big part of the opening letter. Then waiting, like I said, waiting is critical. That's why I have this big hourglass here. Analyzing the response to the letter of the claymation guy with the magnifying glass, looking for the yes. Like I said, we get a lot of no's, but we want the yes. We have to expect the no's. We have to not be defensive when we get the no's. We have to look for the yes. The ground rules, like I said, we don't have court rules. So there's an X on the picture of McKinney's New York court rules. When we do the ground rules, the main elements are, what are we going to negotiate about? Sometimes that takes a lot of back and forth. We're talking about scope. We think, what does it matter? You're not agreeing to anything except what we'll talk about. You're not making a commitment to do anything, but still, the ground rule conversation is our first chance to show the lawyers what collaboration actually means. So what are we going to talk about? We have to toll the statute of limitations because we can't let anybody lose any rights because we're doing collaboration. We have to talk about attorney's fees, not how much we'll get, but that we'll be able to get it as if we filed the lawsuit. And they won't be able to argue like you can in court, well, you didn't get a judgment, so you can't get attorney's fees. So we have to address that. We have to address how to cancel and when to cancel. Some people I know who use this process like to say, if we haven't reached agreement within a year, 6 months, 3 months, 9 months, then this is canceled. I don't like doing that because you never know how long it's going to take. And like I said before, I've kind of erred on the side of sticking with it. So I usually say 30 days to cancel. On 30 days notice, either side can cancel, but you have to address it either way. Any other issues? When do you talk about the ground rules? We talked about that a little. Who signs them? It can either be the lawyers or the clients. And you can have ground rules after a filed case. This is how people have pivoted to structured negotiation within the case. They've actually negotiated these ground rules. So once you have the ground rules, again, it's all about the cat and the lion. And, you know, you want to have information, you want to establish relationships. So every single meeting is about what are we going to talk about? And to our clients, what's relationship we're trying to form? And what kind of convincing strategy are we going to use? It's not just about we need this information or we need this site visit. Participants' best meetings we have are with the clients, and I have a lot of good stories about those kinds of meetings in my book. But sometimes you might have one client who they want to be collaborative, but in their own person, they're not that collaborative and maybe not best to bring to the first meeting. So we have had that situation too. Again, it's about being intentional. Discovery alternatives, we do not hide the ball, which is kind of what discovery is about in the U.S. litigation system. Instead, we talk about, and this is a picture from that Disabled in Here site of 2 Black women sharing dessert. I use this to show we're trying to have relationships. So when we get the information, we're asking for what we need. We never have a problem because we're not on a fishing expedition. And then wanting to make sure my image was good, I looked up eating and negotiation. Turns out negotiation results are improved by sharing food together. So that's like a really perfect meal, perfect picture. So we've done site visits. We don't have depositions, which are just so draining on both lawyers and clients. Before I did this work, starting in 95, I was a lawyer for 10 other years where I represented labor unions and did traditional civil rights cases. And I know the stress from doing depositions. So these are conversations we have, asking for information. Experts without battles. This is the guy from the Chicago College who got hired by the school after he was the claimant because he was the expert. Besides having the clients as experts, the disabled claimants, we often have joint experts. It's not even so much about experts, it's about expertise. We want whoever we're negotiating with to have the best expertise possible. So we've had many situations and people say, wait, you give them your best experts? It's like, I guess we give them our best experts and we could have a protection agreement that said we could have them back if things fell apart, but we've never had to do that. So we're always recommending that, people to hire. We give them 3 suggestions. You should hire this person to be your expert on this because we all want to make sure you have good expertise. Okay, drafting, again, the timing, we talked about that. The scope of the agreement, what fears do we have to conquer? Small experiments, this has been key to the success of structured negotiation. Things can't all happen on the same day, so we don't need the agreement to cover every single thing. With Bank of America, we had the first agreement. I think there were 25 talking ATMs, and we left it open for more negotiations, and we ended up with 3 agreements before we finally got every ATM in the country by Bank of America. When we did the Citibank case, we did a press release that got national press attention for 5 ATMs that talked. And that has been true with everything. Starting small, celebrating small victories, going on to more has been really critical. Having dispute resolution language in case there's a problem. Damages and attorney's fees. There's lots of issues in civil rights cases about ethics. There's disputes. It's the main place I've used a mediator 4 or 5 times over the years to help talk about the money. The ground rules do say and should say where one of the issues is the money, the fees, and the damages. So when we get to it, we're like, well, this is nothing new. Monitoring and implementation, when all you have is a hammer, everything looks like a nail, which is why I have this picture of a gigantic hammer that's on top of a hardware store in Haight-Ashbury, San Francisco. People always say to us, well, you don't have a court order. What happens when things go wrong? Well, we're working with gigantic companies who have thousands of pages of websites, thousands of stores. Things do go wrong. Things go wrong. But the relationship that we've had and the contract language that we have strong language that says we're going to get reports. And if there's a problem, we're going to have conversation, mediation, end with arbitration. Never had to go to arbitration, never really had to go to mediation once we signed an agreement. Because we have the relationship, I know it sounds unlikely, but it always works out. And the reason it works out is because we have strategies to deal with the breach. Sometimes we have to have new structured, when we're dealing with a big store, a big place with like 8,000 stores like Target or Walmart, blind person comes to us with a problem in the store. Sometimes we start a new mini little structured negotiation just to fix that person's problem and get them any money they are entitled to. We have extended time limits. We've never abandoned the result, but we have had to be flexible, another dolphin quality, about reaching the result after the agreement. After expiration, all civil rights cases expire, settlement agreements. In 1 minute, I'll tell you that once I do a deal with someone, I feel my name's on the company. So for many of these companies, I still 10, 50, 20 years later, can call somebody up and say, there's a problem. This ATM is broken. This web page doesn't work. Usually I just do that. No pay to me. There's no agreement. There's nothing written. It's just a fix. Sometimes, this has happened 4 or 5 times, many years later, if it starts feeling like I'm doing free work for a big company and it doesn't feel fair, I write to the company. I say, we need a new negotiation. You have a new owner, or you made a new website, or this is really broken. We have to do it again. And they've always said yes, which again is a testament to the relationship. So building collaborative muscle. This is a picture of Spirit Rock, which is a meditation center in Northern California, where they used to have lawyer retreats, which I went on, to say that you don't have to have a mindfulness practice to do this work, but having some sort of mindfulness practice is helpful. I just wrote here, inhale dolphin, exhale shark, whether it's journaling or walking or meditating. I once did a training and someone said they have a practice of writing in the Bible, a page of the Bible every day for writing their thoughts. Any sort of meditation practice can help this. That's what I got. There's a picture of my book. It's one of the problems with the ABA is they charge too much for their books. So I took it back and I self-published the second edition in 2021. So it's available for half the price, I'm glad to say. And it's not just on Amazon, but it's on online booksellers around the world in paperback and in digital, accessible digital. And that's who I am. So if you have questions about this,